Ruby Ridge was the site of a deadly confrontation and siege in northern Idaho in 1992, between Randy Weaver, his family, and his friend Kevin Harrison, agents of the United States Marshals Service and Federal Bureau of Investigation. The events resulted in the death of Weaver's son Sami, his wife Vicky, and Deputy U.S. Marshal William Francis Degan. At the subsequent federal criminal trial of Weaver and Harris, Weaver's attorney Jerry Spence made accusations of criminal wrongdoing against every agency involved in the incident: the FBI, the USMS, the Bureau of Alcohol, Tobacco, and Firearms, and the United States Attorney's Office for Idaho. At the completion of the trial, the Department of Justice's Office of Professional Responsibility formed a Ruby Ridge task force to investigate Spence's charges. The 1994 task force report was released in redacted form by Lexis Counsel Connect, an information service for attorneys. It raised questions about the conduct and policy of all the agencies. The Ruby Ridge incident and the 1993 Waco siege, involving many of the same agencies and even the same personnel, caused public outcry and fueled the widening of the militia movement. To answer public questions about Ruby Ridge, the Senate Subcommittee on Terrorism, Technology and Government Information held a total of 14 days of hearings between September 6 and October 19, 1995, and subsequently issued a report calling for reforms in federal law enforcement to prevent a repeat of Ruby Ridge and to restore public confidence in federal law enforcement. Development. Randy Weaver, a former Iowa factory worker and U.S. Army combat engineer, moved with his family to northern Idaho during the 1980s in order to homeschool his children and escape what he and his wife Vicky saw as a corrupted world. Vicky, the religious leader of the family, believed that the apocalypse was imminent and believed her family would survive the apocalypse in a remote mountainous area. They bought 20 acres of land on Ruby Ridge in 1983 and began building a cabin. The Weaver property was located in northern Idaho in Boundary County, on a hillside on Ruby Creek opposite Caribou Ridge near Naples. In 1984, Randy Weaver and his neighbor Terry Kinnison had a dispute over a $3,000 land deal. Kinnison lost the ensuing lawsuit and was ordered to pay Weaver an additional $2,100 in court costs and damages. Kinnison wrote letters to the FBI, Secret Service, and county sheriff alleging Weaver had threatened to kill the Pope, the President, and John V. Evans, governor of Idaho. In January 1985, the FBI and the Secret Service started an investigation. In February, Randy and Vicky Weaver were interviewed for hours by 2 FBI agents, 2 Secret Service agents, and the Boundary County Sheriff and his chief investigator. Although the Secret Service was told that Weaver was a member of the Aryan Nations and that he had a large weapon cache at his residence, Weaver denied the allegations and no charges were filed. The investigation noted that Weaver associated with Frank Kumnick, who was known to associate with members of the Aryan Nations. Weaver told the investigators that neither he nor Kumnick were members of the Aryan Nations and described Kumnick as associated with the Covenant, Sword, and Arm of the Lord. On February 28, 1985, Randy and Vicky Weaver filed an affidavit with the county courthouse alleging that their personal enemies were plotting to provoke the FBI into attacking and killing the Weaver family. On May 6, 1985, Randy and Vicky Weaver sent a letter to President Ronald Reagan claiming that Weaver's enemies may have sent the president a threatening letter under a forged signature. No evidence of a threatening letter surfaced, however. The 1985 letter was cited by the prosecutor in 1992 as overt Act 7 of the Weaver family conspiracy against the federal government. ATF involvement. The Bureau of Alcohol, Tobacco and Firearms first became aware of Weaver in July 1986 when he was introduced to an ATF informant at a meeting of the Aryan Nations. Weaver had been invited by Frank Humnick, who was the original target of the ATF investigation. It was Weaver's first attendance. Over the next 3 years, Weaver and the informant met several times. In October 1989, the ATF claimed that Weaver sold the informant 2 sawed-off shotguns, with the overall length of the guns shorter than the legal limit set by federal law. In November 1989, Weaver accused the ATF informant of being a spy for the police. Weaver later wrote he had been warned by Rico V., the informant's handler. Herb Biley ordered him to have no further contact with Weaver. Eventually, the FBI informant Rico Valentino outed the ATF informant to Aryan Nations Security. The ATF agent Biley had come to regard Humnick as just a boastful show-off, and Weaver as even less involved. In June 1990, Biley attempted to use the sawed-off shotgun charge as leverage to get Weaver to act as an informant for his investigation into the Aryan nations. It is clear that, after the gun sale occurred, ATF was not so much interested in prosecuting Weaver as in using its case against him as a carrot and stick to force him to become a government informant against those in political extremist groups, like the Aryan nations, who may themselves have been engaged in significant criminal activity involving guns or explosives. When Weaver refused to become a snitch, the ATF filed the gun charges in June 1990, also claiming Weaver was a bank robber with criminal convictions. Weaver denied the sawed-off weapon charge, claiming that the informant had purchased 2 legal shotguns from him and later shortened the guns. A federal grand jury later indicted him in December 1990 for making and possessing, but not for selling, illegal weapons. In October 1989, ATF agents posed as broken-down motorists and arrested Randy and Vicky Weaver when they were stopped to assist. Randy Weaver was told of the charges against him, released on bail, and told that his trial would begin on February 19, 1991. On January 22, 1991, the judge in the case notified the attorney Everett Hoffmeister that he would be serving as Weaver's attorney. Hoffmeister made several unsuccessful attempts to contact Weaver. On that same day, Weaver called the U.S. probation officer Carl Richens and informed him that Weaver was instructed to contact him on that date. Richens did not have the case file at that time, so he asked Weaver to leave his contact information and Richens would contact him when he received the paperwork. According to Richens, Weaver did not give him a telephone number. The defense counsel Hoffmeister sent letters to Weaver on January 19, January 31, and February 5 asking Weaver to contact him to work on his defense within the federal court system. On February 5, the trial date was changed from February 19 to February 20 to give participants more travel time following a federal holiday. On February 7, the probation officer sent Weaver a letter indicating that he now had the case file and needed to talk with Weaver. This letter erroneously indicated that Weaver's trial date was set for March 20. On February 8, Hoffmeister again attempted to contact Weaver by letter informing him that the trial was to begin on February 20 and that Weaver needed to contact him immediately. Hoffmeister also made several calls to individuals who knew Weaver asking them to have Weaver call him. Hoffmeister told Judge Harold L. Ryan he did not hear from Weaver before the scheduled court date. When Weaver did not appear in court on February 20, Judge Ryan issued a bench warrant for failure to appear in court. On February 26, Ken Keller, a reporter for the Kootenai Valley Times, telephoned the U.S. Probation Office and asked if the reason that Weaver did not show in court on February 20 was because the letter sent to him by Richens had the incorrect date. Upon finding a copy of the letter, the chief probation officer, Terrence Hummel, contacted Judge Ryan's clerk and informed them of the incorrect date in the letter. Hummel also contacted the U.S. Marshals Service and Weaver's attorney informing them of the error. The judge, however, refused to withdraw the bench warrant. The U.S. Marshals Service did agree to put off executing the warrant until after March 20 to see if Weaver would show up in court on that day. If he were to show up on March 20, the DOJ claimed that all indications are that the warrant would have been dropped. Instead of waiting to see if Weaver would show up on March 20, however, the U.S. Attorney's Office called a grand jury on March 14. The USAO failed to provide Richins an erroneous letter as evidence to the grand jury, and the grand jury issued an indictment for failure to appear. U.S. Marshals Service involvement. When the Weaver case was passed from the ATF to the Marshals Service, no one informed the Marshals of the fact that ATF had attempted to solicit Weaver as an informant. As the law enforcement arm of the federal court, it was the duty of the U.S. Marshals to bring in Randy Weaver, now considered a fugitive. Unlike most federal fugitives, who flee across state lines to avoid arrest, Randy Weaver simply stayed at his remote home, threatening to resist any attempt to take him by force. Weaver was known to have an intense distrust of government, and it is believed that the erroneous Richins letter increased this sentiment and may have contributed to his reluctance to appear for trial. Weaver was clearly suspicious of what he viewed as inconsistent messages from the government and his own lawyer, and this inconsistency further enforced his belief that there was a conspiracy against him. Weaver came to believe that he would not receive a fair trial if he were to appear in court. His distrust grew further when he was erroneously told by his magistrate that if he lost the trial he would lose his land, essentially leaving Vicky homeless, and that the government would take away his children. U.S. Marshals Service officers made a series of attempts to have Weaver surrender peacefully, but Weaver refused to leave his cabin. Weaver negotiated with U.S. Marshals Ron Evans, Warren Mays and David Hunt through third parties from March 5 to October 12, 1991, when Assistant U.S. Attorney Ron Howard directed that the negotiations cease. The U.S. Attorney directed that all negotiations would go through Weaver's court-appointed counsel. However, Weaver did not have any contact with the attorney and refused to talk with him. Marshals then began preparing plans to capture Weaver to stand trial on the weapons charges and his failure to appear at the correct trial date. Although Marshals stopped the negotiations as ordered, they made other contact. March 4, 1992, U.S. Marshals Ron Evans and Jack Clough drove to the Weaver property and spoke with Weaver posing as real estate prospects. At a March 27, 1992 USMS HQ meeting, Art Roderick codenamed the Operation Northern Exposure. Surveillance teams were dispatched and cameras were set up to record activity at Weaver's residence. Marshals observed that Weaver and his family responded to vehicles and other visitors by taking up armed positions around the cabin until the visitors were recognized. Threat Source Profile. Beginning in February 1991, U.S. Marshals developed a threat source profile on Randy Weaver. The evolution of that profile was later criticized in a 1995 report by a subcommittee of the Senate Judiciary Committee. The subcommittee is concerned that, as marshals investigating the Weaver case learned facts that contradicted information they previously had been provided, they did not adequately integrate their updated knowledge into their overall assessment of who Randy Weaver was or what threat he might pose. If the marshals made any attempt to assess the credibility of the various people who gave them information about Weaver, they never recorded their assessments. Thus, rather than maintaining the threat source profile as a living document, the marshals added new reports to an ever-expanding file, and their overall assessment never really changed. These problems rendered it difficult for other law enforcement officials to assess the Weaver case accurately without the benefit of first-hand briefings from persons who had continuing involvement with him. Many of the people used by the marshals as third-party go-betweens on the Weaver case, Bill and Judy Grider, Alan Jepson, Richard Butler, were evaluated by the marshals as more radical than the Weavers themselves. When Deputy U.S. Marshal Dave Hunt asked Bill Grider about Randy Weaver, "Why shouldn't I just go up there and talk to him?" Bill Grider replied, "Let me put it to you this way. If I was sitting on my property and somebody with a gun comes to do me harm, then I'll probably shoot him." In the later Department of Justice OPR Ruby Ridge Task Force report, Grider's words were incorrectly reported as a threat made by Weaver. The profile included a brief psychological profile completed by a person who had conducted no first-hand interviews and was sufficiently unfamiliar with the case that he referred to Weaver as Mr. Randall throughout. A later memo circulated within the DOJ opined that the assumptions of federal and some state and local law enforcement personnel about Weaver, that he was a Green Beret, that he would shoot on sight anyone who attempted to arrest him, that he had collected certain types of arms, that he had booby-trapped and tunneled his property, exaggerated the threat he posed. Rivera Helicopter incident following an April 18, 1992 flyover by a helicopter for the Geraldo Rivera, Now It Can Be Told TV show. U.S. Marshals Service HQ received media reports that Weaver had fired on the helicopter. That day in Idaho, a U.S. Marshals team was installing surveillance cameras overlooking the Weaver property at the time of the flyover. The field report for April 18, 1992 filed by Marshal W. Warren Mays reported seeing a helicopter near the Weaver property, but not hearing any shots fired. Weaver then granted an interview with a newspaper reporter in which he, family and friends present denied firing on the helicopter. The helicopter pilot Richard Weiss eventually gave FBI FD 302 interviews denying that Weaver fired on his helicopter. The media reports that Weaver had fired on the Rivera helicopter became part of the justification later cited by USMS Wayne Duke Smith and FBI HRT Commander Richard Rogers in drawing up the Ruby Ridge Rules of Engagement on August 21, 1992. Also, in spite of Richard Weiss's repeated denials that shots had been fired at his helicopter, U.S. Attorney Ron Howen would charge that, as overt Act 32 of the Weavers' conspiracy against the federal government, Randy, Vicky and Harris fired 2 shots at the Rivera helicopter.